Good morning, ladies and gentlemen. I'm very glad to be able to meet with you all this morning, although virtually. Today, I have been asked to talk about the subject of proposed legislative amendments to the Personal Data Privacy Ordinance. And so in the coming 20 minutes or so, I will try to share with you what the development and the aspect of amendments would be. First of all, let me perhaps start with the landscape and context. I think it is an unmistakable fact that there has been increasing expectation on the part of individuals on personal data protection in recent years, and enabling trust to be formed among data users and data subjects would be a very important matter. But trust cannot be an assertion. It has to be built upon visible systems, practices, and behavior. And apart from the stakeholders' expectations, there have been other changes which also impact on personal data privacy protection. For instance, back in May 2018, the European Union has started implemented the General Data Protection Regulation, which provides very strong protection for personal data privacy. And that particular piece of legislation has basically catalyzed the development in privacy protection all around the world, and every economy or every country has been asked whether or not you would be following the GDPR approach. Locally and worldwide, there have been different major data breach incidents. In Hong Kong, audience would remember that back in October 2018, we had a major airline in Hong Kong having leaked personal data of about 9.5 million passengers. And within 5 weeks of time, there were another two data security breach incidents, one involving a credit reference agency whereby newspaper reporter imitating as a political figure can unfortunately get the credit report of a government official, of several government officials. That was unfortunate. And in November 2018, there was a major international hotel chain leaking personal data of about, all around the world, 350 million. So those incidents were major data breach incidents. And apart from that, there has been rapid technological development. We talked a lot about internet, big data development and use of AI, and all that have personal data privacy implication. And earlier this year in January 2020, the government outlined the thinking on the possible amendment to the ordinance, to the Personal Data Privacy Ordinance, and they outlined the direction of amendments to the Electoral Panel on Constitutional Affairs. I tried to regroup the six direction into 4 areas so that ladies and gentlemen could perhaps have better and easier to grasp the essence of the possible amendments. First of all, it is about scope. When we talk about scope, I think you will first of all think about the definition of personal data. That is right. And there is more to come concerning scope. The second aspect, the second area would be the rights of individual. Whether or not we could enhance the rights of the individual, or in what aspects we could enhance the rights of the individual. Even with those 2 areas improved or enhanced, it would be necessary in order for the ordinance to be effective to increase the deterrent effects of the ordinance. So something would be done on that front. And in order to be able to enforce the ordinance more effectively, the process will have to be improved. So there are amendments related to the process. You will be able to see the very brief description as to what these 4 areas will encompass. I will take you one by one in greater detail. First of all, scope. There are 2 aspects of it. First of all, it is about definition of personal data, and the second aspect is about direct regulation on data processes. So what would happen to the personal data definition? The possible amendment would be to expand the definition of personal data. So what's the issue with the current definition? Currently, the definition of personal data in our law is premised on three parameters. First of all, the data has to be relating to living individual, okay? That won't change. Second, the data concerned will have to be something that is a processable or accessible form. That won't change as well. The third element in our current definition of personal data is that the information has to be directly or indirectly practicable to ascertain an individual, ascertain the identity. That means you have to know who the person is. So to ascertain, you have to track down the particular individual, know whom you're talking about. And this is rather narrow scope of definition as compared to what the world right now is. All of us would be very familiar with all those profiling, cookies, location data, which even on their own may not be able to tell who you are, but coupled with other data directly or indirectly could be quite easily to be able to identify the person, i.e. there are personal data whereby people may become identifiable, and this identifiability is what commensurate with what is happening in the internet era. And in countries like Australia, in Canada, and in the European Union, they do not require the definition of personal data to actually try to ascertain the particular individual, so long as the data would be relating to an identifiable person, you will be caught under the net. So we believe that this is an area which we should amend in order to ensure that the law can catch up with the development of the modern age. So this is one aspect of changes in the scope of the ordinance by way of expanding the definition of personal data. Second part concerns a data processor. Currently, the rights and obligations under the ordinance focus on data subjects and also the data users. Data users is the one who controls the collection, the use, and control the personal data. But data processor do not process the data for their own purposes. They are basically the agents of the data users and act according to the instructions of the data users. And what is currently being required in our law is that the data users, whenever they engage data processes, they have to use contractual or other means in order to govern the retention and the security of the personal data involved. That means at the end of the day, if there is any data security breach, the law catches the data users, not directly catching the data processes. The data processes are only under contractual obligations with the data users to manage the retention and the security of personal data or by other means. The problem with this approach is that whenever anything goes foul or something problematic happens, there is always a blame from one party to another. That, oh, the responsibility is not with us. The data processors may try to argue that the data users have not given me enough or adequate or clear instructions. And the data users will argue that, oh, I'm not the one who retained the data. I gave everything to the data center operator. I gave it all to the cloud service provider. And for security, I don't know anything about it. And it is the responsibility of the data processors to manage the data security. So the apportionment of blame is something very difficult to manage, and it is not fair to the data subjects. So what we are going to do is to try to impose direct legal obligation and liability on the parts of the data processes in terms of retention and security of personal data. Data users will not, of course, be responsible for the collection of the personal data because collection comes with a purpose. And this purpose is controlled by the data users who in the first place collect the personal data. And data processors, they do not process data with their own purposes. So they will be, if the law is amended, responsible alongside with the data users' retention and security aspect of personal data. In future, the data processors will also have responsibility to notify data users in case of data breaches without undue delay. I will talk a little bit more about data security breach later on. Right now, we've got a voluntary notification system. In future, we hope to make it a mandatory system. So the second area, which we hope to possibly amend the ordinance, would be to enhance the rights of the individual. We propose to require organizational data users to provide retention policy, and within which stipulation of maximum retention period of personal data. We believe that it is important because there have been cases whereby data users have kept or retained personal data for exceedingly long time. And when you collect or retain personal data for exceedingly long time, you increase the risk of a data breach. And if there is any data security breach, then there would be adverse consequence on the data subjects. We have come across cases whereby banks previously kept data for 99 years without justifiable causes. That was actually a case which we discovered back in 2011. Anyway, what we would try to do is that currently under the Data Protection Principle 5, a data user has to set out its data privacy policy, and that policy has to be accessible by individuals. And in that particular policy, we hope to stipulate in future that within the privacy policy, they have to stipulate their data retention policy, and they have to specify in particular the maximum retention period for different categories of personal data, so that data subjects would know for how long you retain our personal data. Currently, the law only specifies that data should be kept as long as its original purpose of collection remains valid. If the purpose has been spent, you should not continue to keep or retain the personal data, but there is no absolute requirement on any numerical maximum period of personal data retention. In future, for transparency purpose and for easy management purpose, we hope to create this responsibility on the part of the data users. The third area of possible amendment is on deterrent effect. Even with the enhancement of the scope of the personal data definition or on enhanced rights of the individuals, if the law does not have a deterrent effect, it won't do much good for individuals. Right now, our ordinance has very often been criticized as a piece of toothless ordinance. Why? Because currently, if you have any breaches against the data protection principles included in our ordinance, the breaching or the contravention of data protection principles by themselves are not offenses. They could only at most attract enforcement notice from our office, whereby we ask the data users to take remedial actions within a certain period of time. And if we, as a regulator, issue enforcement notice, 99% of the data users would obey our instructions, would follow our advice. So it is not an adequately deterrent measure. And even for mandatory, and even for data security breach, right now it is voluntary. In 2019, last year, we have 139 voluntary data breach notification. That were not too many. and a lot of cases were reported to us kind of alongside or after the press had revealed data security breaches. And so the companies or enterprises concerned were basically forced to report to us. So what we would like to do in future is that first, we try to institute a mandatory data breach notification system, whereby if there are data security breach, the data users would be obliged to report to the regulator as well as the affected individuals. And the second point is about empowering Piracy Commissioner to administer administrative fines. Right now, we do not have this power, and as what I have just said, even breaching the data protection principle is not an offense. And the enforcement notice is not quite an adequately deterrent law enforcement instrument. And if we could administer administrative fines, that at least would hopefully be a measure that the data users would take seriously about it. So what would be the possible amendments? In relation to the mandatory breach notification mechanism, we hope to require the data users, in cases of data security breach, to report both to us and to the impacted individuals. And then we have to think about what the notification threshold should be. There are different schools of thoughts. If you set the threshold too low, then you may be, in particular, we being the regulator, be flooded with a lot of trivial or routine data security breaches. That would not be good because our resources would be limited and we should focus our resources on the most important areas. And you could also try to set the bar higher to focus on the most important or the most serious cases. After having reviewed ordinances in other jurisdictions, we propose to set the threshold slightly at a higher level. Real risk of significant harm, i.e. if data security breaches causes real risk of significant harm, they would be obliged under the law to report to us and also to inform the impacted individuals. And there would be other associated parameters which would need to be considered. For instance, time limit. We propose to allow 5 business days for notifying the regulator. We propose this because you do need to allow some time for the data users to find out what is actually happening once they've got suspicion of data security breaches. If you ask them to report immediately after they've got the suspicion, then they won't be able to tell you too much things. But if you allow them too long, then the data subjects may continue to be suffered without knowing the data security breach. So we think maybe we set 5 days as a period of time. And also borrowing reference from Australia, we believe that there may be a need for allowing a period of investigation for suspected breach, because sometimes those are hacking or data security breach may need a little bit of time to find out whether or not that is false alarm or whether or not there is something really serious going on. But we can't allow them indefinite or indefinite period of time to investigate without letting us know or without letting the impacted individuals know. So this investigation period may be, for instance, 30 days at most. And we also hope to have a power whereby we could direct data users to notify impacted individuals. Because sometimes if the data users consider that the data breach is not significant enough to inform the impacted individuals, but we may hold different views. And in order to better protect individuals, we believe that we should have this power. Sanctioning powers, we mentioned about administrative fines. We hope to be conferred additional powers to impose administrative fines. It is a much quicker way to than going through the judicial process, and with a quicker process that the deterrent effect would be stronger. And maximum level of fine may be a fixed amount or a percentage of the annual turnover, whichever is higher. That is a formula which we learned from the GDPR. Of course, we may not set the same absolute level as high as what GDPR has, which is 20 million euro. Mechanism. There are different stages. First of all, we as a regulator believe that we should give an intention to fine, whereby the data users will have a right to make representation. And after they have made representation, we then decide whether or not we go ahead with the fine and at what level. But at the end of the day, we believe that the system should allow the data users to appeal against the decision made by us. And there are criminal fine levels in the ordinance. Currently, the criminal fine levels are not very high. We propose that we should raise it to an extent that it would create sufficient deterrent effects. Process. Currently, we, being the regulator for personal data privacy, could not investigate criminal offenses under our ordinance. What are the criminal offenses under our ordinance? For instance, offenses relating to direct marketing are criminal offenses, but we cannot investigate them. We have to refer them to the police after we have established prima facie evidence of contravention. This is not good. This is not good because when you pass the case to other law enforcement agencies, they have to do it virtually all over again, despite the fact that we've made our best efforts. Something will have to be redone, and time has to be taken in order to complete the process. And actually, in Hong Kong, there are other regulatory agencies which could administer administrative fines, and also they could conduct criminal investigation. Examples include the Hong Kong Monetary Authority, Securities and Futures Commission, and also the Construction Industry Council. So we believe that having these powers would enable a much better process to deal with personal data offenses or deal with personal data privacy crimes, and with a better process that would bring justice to the affected individuals. So the possible amendments would be to confer powers on this office to carry out criminal investigation and prosecution in our own name. And last year, we have seen a lot of doxing incidents whereby a lot of doxing messages have been posted on different internet forum, websites, discussion forum, etc. And we believe that we should be given a power to apply for injunction orders, which right now we don't have, in order to better protect those affected individuals. So, trust is something very important, and with enhanced improvement in the scope, in the rights of the individuals, in the deterrent effect of our ordinance, and also in the process of operating our ordinance, we hope to build better trust that our ordinance would be able to protect individuals and also afford adequate flexibility for the data users to make use of personal data for their technological or for their industry and trade use. At the end of the day, I believe I have to talk a little bit more about cybersecurity for the audience. A lot of you coming from the ICT sector, data breach is not a matter of if. Data breach is a matter of when. And with the ever-increasing power of the hackers and all the technological developments, whatever safeguard measures or technological advancement you could make to your system, they could be vulnerable to attacks. But I wish to raise one point. Human error is very often the leading cause of data breaches. According to a survey in the United States last year in June, around 53% of data breaches were attributable to human errors. And another survey in United Kingdom earlier this year also showed that 60% of UK businesses had experienced cyber attack or data breach caused by human errors. And there are examples locally. For instance, for the case which I mentioned earlier on, the airline in Hong Kong leaking 9.5 million passengers data 2 years ago, there were human errors like they use certain installed server and it conducts certain vulnerability testing, but somehow they did not manage to detect those vulnerabilities, and the system got going up and running. But that particular vulnerability, upon our investigation, was discovered to have been known to the ICT community for 10 years. So reasonably practicable measures should have been implemented in order to remove that vulnerability. And all these are basically human errors. And the extent of human errors is so serious that last year, in the International Conference of Data Protection and Privacy Commissioner, in October last year, they passed a resolution internationally that call for better human involvement and better efforts to avoid human error in order to provide a better cybersecurity environment, build better workplace culture in order that privacy and personal data security are adequately provided, provide adequate training and education and all that. So do pay a lot of attention to the human side of technology. If you can manage the human side of technology better, you may perhaps at least solve half of your problem. ISO standard, last year in August, they promulgated the new standard, ISO 27701. And ISO hailed it as the world's first international standard for managing privacy information. It builds upon ISO 27001 and ISO 27002 and blends information security management together with privacy management. And this is a piece which could help enterprises to comply with personal data protection laws better. Last, allow me to do a little bit of marketing. If you want to know a little bit more about data privacy, try to join our Data Protection Officers Club. You will be able to enjoy concessionary prices in attending our professional workshop, and you will be given news about personal data privacy regularly. So if you have any question, contact us anytime. Thank you very much.